Thanks for joining us today. Jim Stanziola, myself, Tim DeSetti with Infinitas. We appreciate you taking time to explore a subject that unfortunately will have to be addressed by all of us, and that is the ultimate distribution of our estate planning, whether it be for our loved ones or for our children. It's an incredibly important and sometimes difficult thing to talk about. We built just a short outline today just to kind of hit the key points. Obviously, this can be a very extended discussion, but today's just meant to generate some thought and hit the key priorities in terms of what we should be thinking about and addressing. This particular list that we put up on the slide is going to guide us through the conversation today. Obviously, this is all about distribution of assets, whether it be at your first death or at the second death. If you're a married couple, you need to think about what are the key things you want to do from a distribution standpoint. And Jim, I think first and foremost, it's one of these processes that very few people understand unless they go through it with a loved one, but that's probate. Latin meaning to prove, and it can be, you and I have got certainly some stories about
sure.
Why to avoid that.
Yeah, no, you're right, Tim. And so basically, I'm Jim Stanziola. I'm with the Stanziola Estate Law, and in terms of probate, I describe probate as like touching a porcupine. Okay.
Okay.
I mean, it's a very delayed process. It's costly. It's a public process. Anybody can go down to the courthouse and see how you have your assets distributed. And post-COVID, trying to get anything done through the court-administered procedures is really not very pleasant. It just takes a while. So, avoidance of probate is a primary objective for sure.
Yeah, I've never had anybody tell me a story about touching a porcupine, but I have had people tell me stories about the pain they went through in dealing with a loved one's probate process. For example, property out of state. I know that property out of state is, makes it twice as painful, if not 3 times as painful, because you're really going through multiple probate processes.
Good point. So if somebody has real estate located in another state, you can avoid double probate by effective estate planning.
Yeah, I know, and I also know that business owners are folks that, whether it be just a small business, an LLC, a farm operation, I know that's a really important reason to address, the probate avoidance issue.
Yeah, absolutely.
You bet. So let's say that we've got the proper documents. Obviously, a will take you through probate. But what kind of a document do we want to think about? What's the primary thing we need to think about when it comes to avoiding probate?
Yeah, okay, that's a great question, Tim. And the main document, really the cornerstone of most people's estate plan for avoiding probate, is having a living revocable trust. Yeah. That is the main document that puts people in a position in terms of distributing their assets to avoid probate. It is not something that has to be filed with a court. It doesn't have to be filed anywhere. It's a private document. You only have to share that document with the people that you want to share it with.
Great. So a trust is oftentimes the tool we use. Sometimes you can handle avoidance of probate with just titling, coordinating your beneficiaries or the title of the property as well. Talk about that for just a second.
Yeah, so, in terms of, and you hit really kind of a hot button there, and it's the last item on primary objectives, and that's coordinating your estate plan with how you have your assets titled. And in some cases, you can avoid probate by having your assets jointly titled or beneficiaries of qualified plans, life insurance, that will also avoid probate too. The risk you have with respect to jointly titled property is it not flowing through your estate plan, because by operation of law it passes to whoever the other joint tenant is. So that's why we preach and we emphasize whatever estate plan you come up with, coordinate it with how you have your assets titled.
You bet. I think a lot of people try to take that simplistic approach of just putting the kids on their accounts or changing the title of their asset, when they get elderly. And while that might be one simple solution for that, it really doesn't provide much control. For example,
That's
asset
right.
protection. I know that's something with, if you're listening to this presentation, hopefully you've accumulated a fairly significant amount of assets. When you add up retirement accounts, homes, land, investments, savings, personal property, leaving that with some asset protection is probably really critical.
For sure. And in terms of the typical flow with respect to your assets, how you want them distributed if you're married to the surviving spouse, and then eventually on your children if you have children. At the first death, if you are married, an effective way to give assets to the surviving spouse is a trust that we call a marital trust.
Yeah, and that probably a good transition in terms of the slide. I think we've got a diagram to kind of diagram really how that lays out.
Yeah, the marital trust, and I would say a high percentage of our estate planning clients have a marital trust. And one of the main reasons why they have a marital trust, Tim, is to provide certainty of distribution at the second death. In other words, if the surviving spouse remarries, it prevents the possibility that somehow those assets are going to get mixed up with somebody else's family.
Yeah. Yeah, you and I have done a lot of estate plans. We've got the fortune of working together for over 30 years, and planning has changed. I've noticed in recent years, you and I have redone the estate plans of a lot of folks, because what we used to do was set things aside in what was called a family trust or a B
Correct.
trust.
Yep.
And that was the predominant planning for probably a good couple of decades of our
Yep.
career. But now, contrast that a little bit. Go a little bit deeper, if you would, Jim, in terms of that marital trust. Why do we want to consider that Q-tip or that marital trust over the B trust? I know it's complicated,
Yeah.
but I think this is important for clients to understand.
It is, and but estate planning doesn't have to be complicated, and it doesn't have to be an expensive process. The marital trust provides an extreme amount of flexibility, not only asset protection for the surviving spouse in terms of preventing potential outside influences or creditors getting at the assets in the trust, but the marital trust, which we often refer to as a Q-tip marital trust, provides some benefits to a higher net worth individual. Now, a lot of people don't have to worry about estate taxes, Tim, because of the high federal estate tax exemption we have, which this year is $12,920,000. So if you're married, you basically can shelter over $24 million of assets. So a lot of people don't have an estate tax situation. But going forward, we're not going to know for sure what Congress is going to do with the exemptions. We're not always going to know how quickly our assets grow in value. And what the Q-tip marital trust does for the higher net worth couple is provide some flexibility to make an election at the first death to fund the family trust to avoid paying estate taxes at the second death.
Yeah, so it gives you an either or. You can either fund that from a motivation of estate taxes, or
Correct.
you can fund that from more of a, if you don't have a need for estate taxes, it might give you more flexibility and control.
Flexibility is the operative word there, and you don't have to make that decision until after the first death.
Great. Well, I do think that helps in terms of that explanation. Let's talk through the disposition of the assets at the second death. So I do know that whether you choose a family trust, a marital trust, I know the planning is always going to provide flexibility for the surviving spouse to have all the income, all the principal that they need. But when it comes to that second spouse passing away, talk a little bit about the decision to leave assets in trust for children or to leave assets outright to children, and what goes into that decision for most clients.
Yeah, so great question, and full disclosure here on my end, I'm a big fan of trust and setting up trust for the benefit of your kids and your grandkids and great-grandkids. We refer to those as descendants trusts, and the benefit of doing that is those assets go into this trust vehicle for their benefit and really the benefit of nobody else. If they run into auto liability or have bad marriages or any of the unfortunate things that could happen to someone during the course of their lifetime, those assets that go into their trust are there for their benefit and nobody else. Mm-hmm. That's the primary benefit.
Yeah, they use they use the term, and I've heard you say it, I think, 4,000 times over the course of our career, that ascertainable standard.
Yeah.
So describe that for people, because that sounds intimidating, that I can only access assets by an ascertainable standard.
Yeah, so it's really not as complicated as it sounds. And basically, the language that we use in a trust for the benefit of the kids is, in terms of getting access to the income and principal, they can get access based on health, education, maintenance, and support. So anything that they need to support themselves during their lifetime for those reasons, they can get at the assets in the trust. And we use that phrase instead of the phrase "for any reason." If we use the phrase "for any reason," it's as if the trust beneficiary owns the assets outright. If we use the health, education, maintenance, and support standard, that does have legal significance in the legal business and in estate planning, in that it is considered an ascertainable standard, and that's what provides the asset protection.
You bet. I think one of the questions that I often get from clients when they're considering trusts is, how are the assets going to be divided for the kids? Okay, I've got 3 kids,
Right.
and my, everybody's situation is complicated. What if the life insurance comes in, the IRA comes in, you've got a home or a family farm or a business asset? How do assets get divided? As a practical reason, how do assets get divided in the event of a second death?
Well, now we're talking about a couple's legacy or a person's legacy in terms of what they have when they die and what goes on for the benefit of their kids. And it's your legacy. You can do whatever you want with it.
Right.
You can divide it equally, and typically if you are using a trust, what a lot of our clients do is they use separate equal trust shares, but they can divide it any way they want. The one thing to keep in mind there is, with respect to things that pass by way of beneficiary designation, how you have your assets jointly titled, make sure you run those through the trust to get the benefits of however you want your assets distributed.
Perfect. I think in summary today, it's really important to understand that our job as financial advisors is really just to help you make an informed decision. A good attorney, can walk you through, unfortunately, the complex parts of this and try to keep that simple and applicable, to your own unique situation. And I think one of the things you'd agree with, Jim, is every situation we see is unique.
You bet.
And everybody has their own separate goals and objectives. While this isn't easy to talk about, it's definitely something that's critically important. Whether you don't have a plan now, or whether you have a plan and it just hasn't been reviewed, numerous legal changes have occurred. We were talking about the marital trust versus a family trust, why that's important to know which way your plan document reads, as well as the fact that we have a large estate tax exemption that is going to expire under current law. And so the rules and the laws will be changing in the future. So Jim and I want to encourage you to, if you have an attorney that you work with and you have a great relationship, let us engage with them and work with your outside counsel and join you in those meetings and have a more full-fledged discussion. If you don't have an attorney that you're working with, or you would prefer to kind of keep things in-house, I know Jim and I have been working on numerous cases within the office, and we'd be glad to sit down. Jim's contact information with Stanziola Law is on the screen now. So if there's any way we can help you, please feel free to reach out to us. Thanks so much for joining today.
Thank you.